And on behalf of the Washington, D.C. chapter, lawyer chapter of the American Constitution Society, I would like to welcome you to today's panel, Financial Inequities in an Unequal World. Before we get started with this panel, I want to invite everyone. We've got another amazing panel next week on Monday, Preserving Roe and the Rule of Law, another timely panel, unfortunately. And I would invite everyone to register and join us for that. It's December 13th at 2 p.m. Eastern time, so it'll be in the middle of the afternoon. A nice light topic right in the middle of the afternoon to kind of do a little palate cleanse from work. I'm sure whatever you're doing is nowhere near as exciting as what's happening in that realm. With that, I would like to remind everyone that the Q&A is open, so please feel free to put any questions in the Q&A, and I will turn it over to our moderator today, Caitlin Logan Wimmer. Please take it away.
Hi, everyone. My name is Caitlin Logan Wimmer, and I am the co-events chair for DCS or ACS's DC lawyer chapter. In my day job, I work with Maryland Legal Aid as a domestic violence and family law attorney. I am so excited today that you have joined us and are going to be able to hear from an incredible group of speakers that we've put together. The way the panel is going to work today is I will introduce our panelists and give a bio, and then they each are going to for around 15 minutes, just share their own unique perspective and research on inequities really in tax law, but also I think in our current system. And so that is the common thread that unites all of them. If any of you know Professor Hanneman personally, one thing that she says in all of her classes and in the hallways and anytime you interact with her, she'll say, everyone should take tax law because it impacts every area of your life and of the law. And so I think that truly, sets us up today for what you are going to hear from our panelists and the ways in which, their research really covers so many levels of inequities in so many areas of our life. So, in addition to that, there will be time for questions at the end. So please add them into the chat. I'm excited to see what questions you all come up with. So our first speaker is Allison Tate. She is the current Dean of Faculty Development and a professor of law at the University of Richmond, where she teaches trust and estates, family law, estate planning, critical theory, and feminist legal theory. Professor Tate joined the University of Richmond law faculty in 2015. Before coming to Richmond, she was an associate in law at Columbia Law School. She also clerked for the Honorable Richard Palmer of the Connecticut Supreme Court and spent a year as the Gender Equity Postdoctoral Professor or Postdoctoral Fellow for the Yale Women Faculty Forum. Professor Tate's research addresses the regulation of family and household economies and the ways in which this regulation produces complex forms of inequality. Her research takes up questions of entitlement and disposition, and she writes about the ways that family wealth rules help to embed differences among the axis of gender, race, and class. She's written articles about the legal framework of high wealth exceptionalism, the use of family trust to safeguard social and cultural capital, the role of marriage in the creation of economic privilege. She is currently working on a project that pairs the legal governance of high wealth families with that of families living in poverty and explicates on how those polar economies of excess and extraction replicate colonialist formations. I'm sorry, I can't speak today. And I just realized I went out of order. So Professor Tate, are you okay to start us off?
I'm okay, unless Professor Crawford really wanted to go first. I think she was slated to go first, so I don't want to ruin any timing issues that she might have had. Otherwise, I'm fine.
Okay. Then we will go ahead and get started with you. My apologies.
Okay, great. Well, thank you for that nice, lovely introduction. And I am totally delighted to be here today. So thank you for organizing this, and in particular, thanks to Professor Hanneman for organizing such a great panel. So as you said, I'm talking about definitions of families, basically, and how these definitions that are embedded in the law either help families gain money or deny families access to forms of wealth. And it's part of the project, the last project you mentioned, about sort of the pairing of families living in and around poverty and high wealth families. So again, I will talk about the inequality and how it relates to and can often be traced to legal definitions of the family. And as we all know, without having gone to law school, that family is an extremely fluid concept. It's a very malleable concept, and it's contingent on all kinds of factors, including historical practice, the political will of the community, cultural norms. But what's important in the legal context and what differs in the legal context between families is which family forms the law recognizes, sanctions, and subsidizes. So what a family looks like and the connective threads of law and biology that attach family members to one another are paramount in determining what economic benefits a family can claim. So what inheritance rights a family member might possess, how a family member might be treated, or how an entire family might be treated in contexts as diverse as tax law and housing law, other forms of law. So how a family is defined within legal parameters, it can quite literally make or break a family financially. And the most obvious example, there's lots of good literature on this. The most salient example in US history is the legal refusal of family status to enslaved individuals, a refusal which was obviously grounded in colonial politics, plantation politics, and has been the root cause of many forms of racial wealth gaps that have evolved. And as that example shows, what historically has been the primary lever of access to resources is marriage. The marital family has been a fulcrum for distribution of funds within the political economy as we've constructed it to privatize dependency. There are basic rights that spouses have through marriage to one another's wealth, either at divorce or at death. And marriage has also become, over time, the means for accessing just what I tell everybody in family law is the biggest subsidy package available. All kinds of rights and entitlements, and Obergefell made that clear. So in these ways, the state's tireless monofocus on marital families has privileged those families that tend more typically to cohere around the notion of an idealized nuclear family. And what I'm interested in is not those families, not the nuclear sort of idealized families, but the families on both the low income end of the wealth spectrum and the high wealth end of the spectrum. And what I want to talk about a little bit is how both groups are not served well by this notion, this focus on the marital family. Families at both the low income end of the wealth spectrum, as well as those on the high wealth end, tend to be less embedded in this sort of limiting and very limited view of the family. And they tend to live or conceptualize their families differently in more extensive and expansive ways, connecting many family branches and through generations. So I'll just a little bit about each end. On the low income end of the spectrum, findings have shown that only a minority of working class Americans are married, and those living in poverty are almost 3 times more likely to cohabit than their comparable middle and upper class peers. And this is in the age group of 18 to 15, so it was squarely in the sort of marriage age. And there's lots of studies about what's been called the marriage divide, this divide between low income and working class families and those families with more wealth. So on the low income end of the spectrum, there tend to be many more non-marital families. On the other end of the spectrum, so the high wealth end, high wealth families do tend to be marital couples. Certainly, middle and upper class families tend toward marriage. But I'd like us to just think about how these families don't necessarily benefit from the idea of the nuclear marital family. And this idea does not necessarily meet the needs of ultra-rich families when they're doing wealth management and wealth planning. The idea is that for high wealth families, the family is more than a nuclear group. It's sort of an institution. It's a corporate entity. It's oftentimes very literally a corporate entity, right? It's fulsome, and it's a legacy and a tradition. So high wealth families also tend to characterize families as inclusive of multiple generations of descendants, multiple collateral branches, and other chosen family members, such as maybe step relations or former spouses. So in this way, families at either end of the wealth spectrum tend to find the marital norm confining and maybe not necessarily conducive to their flourishing. The critical difference, which is predictable, I would say, between low income and high wealth families seeking a more expansive view of family is that the low income families rarely succeed in obtaining more capacious definitions, and high wealth families often do. So I'm just going to give two examples. One example of a very narrow definition of family and how that works against certain communities and certain groups, and then one example from the more expansive. And just from the outset, there's only two examples, so it's very clear that I've picked ones that work for my purposes. And there's a lot of texture in terms of how families are defined across statutes and across areas of the law. There's some better and worse, both in the low income context and in the high wealth context. But I do think there are trends on either end, and we can talk about that in the Q&A. So on the narrow end, sort of narrow focus on the marital family, I just want to mention housing and zoning laws. They've been notorious for being restrictive. People have written a lot about this. And again, zoning laws have been traditionally beset by very narrow definitions of what a family is. These statutes have regulated the composition of neighborhoods over decades and have introduced social discipline and norming into families through the single family requirements. And these rules are important in terms of wealth, since we're talking about wealth creation, wealth transfer, and wealth inequality. They're important because they determine a family's ability to live in neighborhoods with good schools, public libraries, and even baseline amenities such as clean water and good roads. All opportunities. It's a geography of opportunity. And Ralph Ellison summarized it very nicely. He said, geography is fate. So you might say geography is wealth. So I'll just give you the typical zoning statute works through what they're called blood marriage and adoption. So they're what most jurisdictions have. So a typical statute says family is one or more persons residing in a single dwelling unit, unless all members are related by blood, marriage, or adoption. No such family shall contain more than 3 persons. So in this scheme, some of the largest burdens clearly fall on non-marital couples and myriad variants of queer families. And I'll just give you one example. This is from 2006. A couple, Olivia Sheltrack and Fondre Loving, relocated their family to a suburb of St. Louis, and they were denied their occupancy permit in their new house that they bought because their family was in violation of this blood marriage or adoption ordinance. And they were in violation because they were unmarried. And in addition to raising their own 2 biological children, they were raising one of the partner's children from a previous marriage. So they were fined $500 a day while they continued to live in their own home because they were in violation of this ordinance. This was a case that the ACLU took up. They filed suit against the town, and the city council ultimately voted to change the ordinance. And a lot of ordinances, there's a number that have been changed in the last, I would say, 5 years. Nevertheless, one of the partners, Sheltrack, recognized the inherent prejudice of these zoning laws and the message, and commented that the town was sending a clear message to residents. And this is what she said. The message was, don't be gay, don't be unmarried, don't be poor, don't have children out of wedlock, and don't be a foster parent. So that's kind of a really, again, very narrow definition. I'll just kind of point this out as again, how there's a differential in how rules are applied. Most of these statutes do make exceptions for domestic staff. So if you are a family that has live-in help, that has domestic servants, domestic staff, as they've been historically labeled, those are actually exempted from the blood marriage adoption rules. So that's another thing to talk about. So anyway, that's a narrow rule, and you can see how it sort of penalizes certain families, and again, strips them of the opportunity to live in particular geographies where they might have access to various resources for wealth creation. Then when we enlarge the scope of analysis and capture rules governing high wealth families, the story is often wholly different, and some of the definitions are as broad as others are in the low income context, as those are narrow. And the one example I just use here is family offices. And I think family offices are a clear example of how high wealth families organize their worlds through these offices. And a family office is just basically an office that is an investment arm. It's used for high wealth families to invest their money. And people like them, high wealth families like them, because they receive specialized legal treatment in the form of an exemption from the definition of investment advisor under the Dodd-Frank Act. So all family offices have to do is mind the definition of family clients and family members set forth by the SEC, and they benefit from the exemption. And the definition here of family members is as capacious as the zoning one is narrow. So a family client or a family member, according to the SEC, is a family member with lineal kinship to the designated relative within 10 degrees, a family member with collateral kinship to the designated relative within 9 degrees, adopted children, stepchildren, spouses, former spouses, including spouses and formers within 5 degrees of lineal kinship, family affiliates and affiliates directors, a trust not owned by a family member if at least one family member is a beneficiary, and a charitable foundation as long as a family member is an organizer, incorporator, officer, member of the governing board, trustee, major donor, or non-charitable beneficiary. So you can see it's relatively different, incredibly expansive in a way that the zoning ones are not. And you might wonder why we care. Why does that actually produce wealth? Having that type of definition for a family office allows a greater number of people who are defined as family members to basically benefit from this form of financial privacy and this form of investment and access to investment opportunities that other individuals might not have. And also just keeping earnings, transactions, and ownership out of sight from both the public and regulatory authorities. There was an article pretty recent, a couple of years ago now, in The Economist, and they were talking about family offices. And this is what The Economist said. The Economist, never your most progressive publication. They said, as family offices become more complex and hungry brokers are rolling out the red carpet, tax wheezes become easier. So those might be some of the ways in which family offices, again, provide, or enable benefits to a greatly and expansively defined family. So uncovering these points of connection and disconnection help make visible how the economies of wealth and poverty are twinned, sort of in this, I like to think of it as a phantasmagoric way. It's a distorted reflection of one another. And it's important to recognize that they are profoundly not just twinned, but also entwined. And I think it's possible to suggest that legal templates of family money represent shifting colonialist formations in sort of deeply unsettling ways, and that they enable the enrichment of one group, one population, while stripping the other of opportunities to accumulate and pass down wealth. And it happens along predictable vectors of race, gender, ethnicity, ability, and other forms of minoritization. So just to sort of flesh that out a little bit, family definition rules disallow certain families from meeting the requirements for some programs, for some governmental benefits, for housing, for, again, access to certain neighborhoods, thereby constraining their ability to receive and to build family money. And it's neither trivial nor accidental that the constrained populations tend to be non-white. You can look at the statistics about marriage rates and look again how that the marriage divide maps itself out according not just to income, but to race and ethnicity. Also constrained in terms of populations are LGBTQ and queer families, sort of broadly construed. Among couples raising children, same-sex couples are 7 times more likely than their different sex counterparts to be fostering or to raise adopted children, just as one example. So the exclusionary standards work against non-white families, predominantly work against queer families, and those families generally who more often choose arrangements that draw in multiple parents, chosen children, and multiple family members across branches and generations that are cast as peripheral in the normative vision of family.
And Professor Tate, if you want to provide a closing thought at this point.
I'm like 1 minute away. So alternately, high wealth families who manage their wealth through forms like the family office accumulate more wealth, they preserve more wealth, they transfer more wealth. And what's notable about this population is their blinding whiteness. White wealth creates white wealth. And again, This leads to increased inheritance in the form of white wealth. And there's, again, a big literature out there about inheritance being one of the primary mechanisms of creating advantage and privilege, and a basic, inheritance being a basic mechanism for class stratification. And I'll just give you one little statistic and then close up. Mapping onto patterns of deficit, white families are much more likely to inherit than Black counterparts, 5 times more likely, actually. And even among those receiving inheritances, Black families received less. Black families received 8 cents of inheritance for every dollar inherited by white families. So accordingly, inheritance practices entrench rich and poor in their economic landscape and amplify the dynamics of financial domination. So in closing, it is not, as some might claim, that the legal rules have a disparate impact on rich and poor. Rather, the rules themselves, as well as the financial results, are monuments to a political and economic memory. They're materializations of power retained and exercised, and they're embodiments of financial circuits that are grafted onto a colonialist society. I will stop there.
Thank you so much, Dean Tate. I'm excited to dig into that a little bit more when we get to the questions. So our next speaker is Professor Bridget Crawford. She teaches federal income taxation, estate and gift taxation, and wills, trusts, and estates. Her scholarship focuses on issues of taxation, especially wealth transfer taxation, property law, especially wills and trusts, tax policy, and gender and the law. Professor Crawford's scholarship has been published in journals including the Washington University Law Review, the University of Chicago Legal Forum, Boston University Law Review, UC Davis Law Review, Washington and Lee Law Review, and specialty journals at Harvard, Yale, Columbia, the University of Pennsylvania, and the University of Michigan. Prior to joining the faculty at Pace University School of Law, Professor Crawford practiced law at Milbank, Tweed, Hadley, and McCoy LLP in New York, now Milbank LLP. Her practice was concerned with income, estate, and gift tax planning for individuals, as well as tax and other advice to closely held corporations and exempt organizations. Professor Crawford is a member of the American Law Institute and the American College of Trust and Estate Council. She is the former editor of the ACTEC Journal. Professor Crawford is the former chair of the AALS section on women in legal education and the AALS section on trusts and estates. She is one of the 26 law professors profiled in the book by Michael Hunter Schwartz et al., What the Best Law Teachers Do, recently published by Harvard University Press. From 2008 through 2012, Professor Crawford served as Pace Law School's inaugural Associate Dean for Research and Faculty Development, and she served again in that role in 2014 to 2015. Her book, Feminist Judgments, Rewritten Opinions of the United States Supreme Court, co-edited with Linda L. Berger and Catherine M. Stanchi, was published by Cambridge University Press in 2016. I'm very excited to add that to my list of books to read. Her following book, Feminist Judgments, Rewritten Tax Opinions, which was co-edited with Anthony C. Infanti, was published by Cambridge University Press in 2016. Professor Crawford is the co-editor of a series of feminist judgment books that cover a wide range of subject matters. Professor Crawford is the co-author of 3 case books: Federal Taxes of Gratuitous Transfers, Law and Planning, with Joseph M. Dodge and Wendy C. Gerzog, the 7th editions of Federal Income Tax Cases and Materials, Joel Newman and Dorothy Brown, and the 2nd edition of Wills, Trusts, and Estates, an Integrated Approach with Denia C. Wright and Michael J. Higdon. So you can see we are definitely in good hands with Professor Crawford. So I will now turn it over to you.
Great, thanks so much. I'm going to share my screen and get my slideshow going. While I do that, I am also going to turn off my camera so I don't have any connectivity problems. Right here on the screen, you have the Twitter handles of everyone who is speaking today. Mine followed by Victoria Hanneman's and Allison Tate's. thank you to the DC lawyer chapter of the ACS for facilitating this conversation. Thanks to Professor Hahnemann for organizing us to talk about this important issue of financial equities in an unequal world. In my view, economic inequity is deeply, deeply intertwined with and part and parcel of some of the most important issues of rights and justice in our time. I'd like to focus my time today on what is commonly known as the pink tax. That's an umbrella term for a whole bunch of taxes, literal and metaphorical ones associated with stereotypical femininity or things that those who are historically called women use. I should say at the outset that my version of women includes all female identifying people, cis, trans, gender non-binary, and femme presenting people. So consider a very simple example you might find at your local drugstore. In New York City, a government research group found several examples where prices of comparable products varied based on whether it was a so-called man's or boy's product or a woman's or a girl's product. And we have some simple examples from this study of gender pricing. Some body wash in the blue bottle cost $1.29 for the men's 3-in-1 shampoo. But for the ladies who want to revitalize and condition with blackberry sage tea, they have to pay 70 cents more for the privilege. Another example, I missed an example that I really like. A pink scooter, the same scooter in pink costs $20 more than the red scooter. And of course, there's no federal rule prohibiting different pricing along these lines. California has legislation that provides that no business establishment can discriminate with respect to prices charged for similar or like kind services because of gender, but very few states have followed California's example. And we know that women pay an upcharge for certain services. That could be in the form of a haircut. Even if a woman has a simple haircut, even if her haircut takes the same time as a man's cut, she is likely to be charged more. A women's pleated silk blouse might in fact take more time to dry clean than a simple men's shirt. But what happens when you've got two button downs or largely similar, one is blue and one is red, when a launderer or a dry cleaner charges different prices to clean this shirt? It's pretty hard to understand why the woman's shirt would cost more. And that is what we call the pink tax. According to some folks behind this website, Axe the Pink Tax, a 50-year-old woman would have already spent during her lifetime more than $68,000 above and beyond what a man would have because of that pink tax. The different pricing for products or for services associated with things that women or girls typically use. And of course, in talking about pricing differentials, we're not talking about an actual tax. There's no actual tax involved in this particular calculation. So for us lawyers, that's not especially useful. It doesn't take into account geographical differences, but it's a blunt way of making a larger point that it's really expensive to be a woman. But there's, of course, another major arena in which households that contain women and girls are economically disadvantaged by an actual tax, and that is the sales tax imposed on menstrual products, typically tampons and pads, by 27 states in the United States. Now, to back up here for just a minute, for those of you who have never taken a tax class in your life, you still know what a sales tax is. Each state in the US and the district can decide whether it wants to have a sales tax and what that tax will be. There are 45 jurisdictions in the US that have a sales tax. And generally speaking, a sales tax is imposed on the sale of all things, tangible property. But every state that has one of these sales taxes or jurisdictions like DC also has exemptions for things like medicine, medical devices, food, and some jurisdictions clothing. So we might think of this distinction as mapping along the lines of necessities versus non-necessities. Of course, that's not entirely the case, but that's a rough way of talking about it. So enter into the discussion menstrual products, tampons, pads, menstrual cups, other products that half the population uses once a month or more for large portions of their lives. And in 27 states, these products are subject to a sales tax. I'll call that the tampon tax. The rate of this tampon tax is all over the place. Depending on the jurisdiction, it can range from sort of 4% to 7%. And those are just base taxes. Cities or counties may impose tax beyond that. But very interestingly, the states that have the tampon tax are not predictable along a conventional blue state, red state dichotomy, or even geographical lines. You'll see from this little quick count here that the dichotomy is not as necessarily predictable. Louisiana recently repealed its tampon tax. Florida has no tampon tax, but places where you might expect to see some more progressive values continue to maintain a sales tax on menstrual products. And some of those on the left-hand side, I acknowledge, have changed their laws just in the few last years. In fact, this whole issue of the tampon tax took on salience probably starting in around 2015, when none other than Cosmo magazine sponsored a petition urging state legislatures to stop taxing our periods, period. That was based on a similar petition begun in the UK, since adapted in many other countries, but still inequality persists. Courtesy of the first non-profit law and policy organization fighting for menstrual equity called Period Equity, in partnership with the product manufacturer Lola, we have some very noticeable and social media friendly examples of the injustice of this tax, where licorice is taxed in Arizona, but are not taxed. Licorice, eat all you want, tax-free, but your periods, you know what to do. Pay the tax man. Swim, go to swimming pools with paying no taxes, but your tampons pay. Bingo supplies, knock yourself out. Tax free. And of course, private jet parts, which I think Allison Tate most certainly would have something to say about those private jet parts. Period Equity, this organization I mentioned, has announced its intention to file a lawsuit in every state that still has that sales tax on tampons. And the basis for that lawsuit is an argument I developed with my colleague Emily Gold Waldman, talking about, or trying to advance the argument that this sales tax is a form of impermissible gender discrimination, saying that because these products are so closely tied to female reproductive anatomy, it amounts to a tax on women, just as Justice Scalia said a tax on yarmulkes would be a tax on Jews. So too, we reason that a tax on menstrual products is a tax on women. The most recent group, the most recent state to add to the ranks of this 23 is Michigan. Michigan repealed its tax only after getting sued by Period Equity. And I think Period Equity was only able to do that to mobilize with support from private sector attorneys who were willing to take on the case pro bono. So regardless of where we all work in the field, there is a role for anyone who is interested in these issues. There are lots and lots and lots of more examples of pink tax. I just want to mention two. There's a pink tax on transportation. Some scholars associated with the Wagner School at NYU found that women who can afford to change their mode of transportation when they need to for safety reasons. So women who ordinarily would take the subway instead choose to take a taxi or a ride-sharing service if they're traveling at night, if they can afford it. Of course, not everyone can afford it. But practically speaking, what does that mean? It means that women who work at night, nurses, bartenders, fast food workers, office cleaners, are suffering a financial disadvantage vis-a-vis their male counterparts, and vis-a-vis women who work in the daytime. So women who are automatically in a precarious position because they may not have full-time jobs, they do shift work, they're paying extra to hang on to the bit of financial stability they have. And to give the second example of the pink tax, we have to talk about this number, really big and bold right there on your screen. You can't miss it. According to Bureau of Labor Statistics data, women still make 82 cents on the dollar for what men make. Of course, that's the median ratio of all women's earnings to the median ratio of all men's earnings, 82 cents on the dollar. When you control for experience, industry, geographic location, job title, that gap does shrink. But the difference in the controlled gender gap still remains and is economically significant. It has been unchanged for the last 6 years. The largest uncontrolled pay gap is experienced by what the Bureau of Labor Statistics calls American Indian and Alaska Native women. These women are making just 69 cents on the dollar for every dollar earned by white men, and Black and Hispanic women, again, to use the terms of the Bureau of Labor Statistics, are not equally, but also extremely disadvantaged compared to white men. Okay, great, or bad. Many years, feminists and other thought leaders have tried to fashion a remedy by creating paid parental leave. If only we had a gender-neutral family leave policy, men would be incentivized to engage in childcare providing. And then separately, women who had taken time to engage in caregiving, they need to be able to join the workforce again without financial penalties. The New York Times reported a few years ago on the unexpected results of a study of California workers. California had been the first state to offer paid family leave beginning in 2004. And researchers found that women who took paid leave, in fact, both earned less and worked less 10 years later. So the preliminary indication is that paid leave isn't all it's cracked up to be for women, and it hasn't necessarily changed male behavior. Men were just 15% of all of the claimants for family paid leave overall, and the average man took just 2 or 3 days of paid leave. My guess is he went golfing. So
Professor
challenges.
Crawford, oh, sorry, if you can just provide your closing thoughts.
Challenges remain in the workforce and at home. The balance of caretaking, at least when a child is young, does not seem to have changed. The COVID pandemic, of course, has complicated all of that. There is much, much more to say about pink taxes and the way that tax is this important lens for evaluating gender equality for people of all colors and all gender identities, but I will not intrude on my co-panelists' time, so I stop there and I look forward to more discussion when we get to the Q&A. Thank you very much.
Thank you so much, Professor Crawford. Okay, our final panelist today is Professor Hanneman. She's presently the Frank J. Kelleher Professor of Trust and Estates at Creighton University School of Law. She teaches courses addressing various aspects of taxation, wills, trusts and estates, and business associations. Prior to coming to Creighton, she was awarded the Student Bar Association Professor of the Year Award at both the University of Laverne College of Law and California Western School of Law. Professor Hanneman also visited the William S. Boyd School of Law, the University of Nevada, Las Vegas. Professor Hanneman co-authored the book Making Tax Law from Carolina Academic Press with Daniel M. Berman, formerly the director of the Graduate Tax Program at Boston University School of Law. She has also published more than 20 law review articles, essays, and/or book chapters in journals that include Harvard Journal on Legislation, Virginia Tax Review, Wake Forest Law Review, and University of Richmond Law Review, the Oklahoma Law Review, Nevada Law Journal, and Columbia Journal of Gender and the Law. Professor Hanneman serves as secretary for the Association of American Law Schools, Trust and Estates section, secretary of the AALS section on women in legal education, and on the board of directors for ClassCrits. She is licensed to practice law in the state of California. Professor Hanneman is a regularly engaged expert by media, including PBS NewsHour, National Public Radio, the New York Times, Wired, and Forbes. Professor Hanneman's recent scholarship focuses on taxation, the debt services industry, and student loan debt. She has a particular interest in industry disruption, emerging markets, and women in the law. So please take it away, Professor Hanneman.
Thank you. Thank you for inviting me. Thank you to ACS in DC for hosting this. And thank you to my co-panelists. I do want to mention that one of the things that is not in the bio of my co-panelists, which they both have incredibly impressive bios, but one of the things that is not mentioned that makes this so special for me that they both agreed to join this panel today is they are both law professors that help women up behind them. And so I really feel privileged to be on this panel with them and that they agreed to do this because I have a great admiration of the work that both of them do in the academy. So I would just start out by saying that I write on the intersection of tax law and the death care services. I have a lot of proposals in play as to how federal tax law can be used to reshape and improve the death care industry. But what I find when I speak about this is really these proposals are the subject of a book. And I don't know when I started writing about this that I necessarily planned on it being the rest of my life's work in multi-volume treatises, but that is where I am going. And what I find is that people who are not familiar with this topic ask me why, because I think the average American has not spent a lot of time thinking about death. We are kind of a death-phobic society. And I mean, perhaps a little bit less death phobic. We're thinking about it more because of the pandemic, but we are a little bit death phobic. So I'm going to speak about what's at stake here, the issues with the industry and why this matters, and frame that out for you, and speak less about the tax side of this, because I think that the tax reform is extraordinarily important, but to situate the tax reform for you, you really have to understand why this matters and why we need the tax reform. Let me hit share screen. So I would start out by saying that this is a unique consumer space. I really like discussing the process that a consumer goes through to purchase a car. Now, imagine if it was the norm for a car shopping consumer to only spend 4 hours and do no price comparison and rely entirely upon one salesperson who was completely biased, and do all of this when you are grieving and have gone through one of life's most devastating events. And this closely tracks what happens in the United States with death care plannings. Very few adults do any lifetime planning for cremation, composting, funeral, burial, or any type of memorial. Now, I can tell you that there is a choice to be made here, an economic choice. We can engage in pre-need planning, meaning before death, or we can engage in at-need planning or after death. We have, as a society, made a choice that skews in favor of at-need death care planning, meaning that we do not deal with this expense until the last possible moment. We have created a norm in this country of distress purchasing. We buy death care services when we are grieving, time constrained, and unable or unwilling to do much research. And so what we've done is we've created information asymmetry. The death care industry holds all the cards. The consumer is relying upon the advice of a professional who always has a profit-seeking objective, who always has a bias, and the consumer has etiquette uncertainty. The consumer doesn't know when he or she or they can and cannot push back on what they are told. The often undiscussed issue here that I like to unpack in my research is that an important economic choice is made when the consumer picks up the phone and calls a funeral home in a panic because somebody has died in their home. It's unlikely that they've done any research ahead of time. It's unlikely that any pricing is available online, and it's not required that it be available online. According to a National Funeral Director Association study, only 16.8% of consumers have visited or called more than one funeral home. That means that the consumer is limited to the menu of options and prices at the first place they go, the first call they make. And prices can vary 40 to 70% in the same metro area. We need to really not underestimate the time pressure on this consumer. Decisions are perceived as final. Cremation's absolute, all genetic material is destroyed. It's not like we revise obituaries. We can't return caskets. We can't take embalmed remains and change our mind and put them in a green cemetery. The special moment of the funeral can't be redone, and we can't fix a funeral ritual that does not feel right. And so there's a time pressure here. We also need to not underestimate the fact that a grieving consumer is cost insensitive and is avoidant. They struggle to make logical and rational decisions. The bereaved prefer to delay decision making. They turn to the person next to them and frequently say, "What would you do here?"
And that's troubling when the person next to them is biased, right? Is the funeral director. And many of us are familiar with the tactics that are used by the death care industry to exploit the consumer, which I have put up on the PowerPoint. So suffice it to say, this is the third largest expense in the life of the average consumer, but we have a consumer that behaves aberrationally here. The deck is stacked against the consumer. So that's really the first point that I wanted to make in this talk today. The second talk that I wanted to make is that the easiest way to bear an expense is to spread it over time. And by shifting norms in favor of at-need purchasing, we are taking that away from consumers. The inability to prepay for these expenses in a reliable way is driving what I call funeral poverty. Fewer than 4 in 10 Americans are able to bear an unexpected $1,000 expense out of savings. And we saw the substantial number of withdrawals from retirement accounts as a COVID emergency measure under the CARES Act, which really should be signaling to lawmakers the importance of emergency savings. But what's even more problematic regarding death care expenses is that lower income families spend far more on death care expenses than higher income families relative to total expenditures in every year that's been studied since 1996. Now, there's societal and cultural baggage to unpack with that one. And spending on death care is often more than just about money. Consumption within this space really tends to operate as a status marker, right? We are spending on death care to satisfy community expectations and to avoid peer judgment. But frequently, the wealthiest 1% spend the least out of everybody on death care expenses, which is fascinating. I've included on the PowerPoint some interesting social media points as posts that were popping up during COVID related to this topic of funeral poverty. So the third point that I wanted to make to everybody is that we're dealing with a death care industry that is entrenched. We are dealing with an industry that by 2023 is projected to make $68 billion in profits. This is a death care industrial machine that has risen. There is an incentive to maintain status quo. And this is more than just a conversation about fusty death care services laws. This is a conversation about what I call regulatory capture. It's a conversation about an industry that may have gained excessive influence over the regulators that are regulating it. And it's important to think about the fact that not much has changed in the way that we handle death care over the past century. And that's a signaling device to you that regulatory capture may in fact be an issue here, because the law that is supposed to protect consumers is also creating barriers to entry for those who are trying to bring innovative death technology to market. Now, this is rent-seeking behavior. This is unnecessarily imposing costs to preserve status quo. It's very difficult, I would tell you, to write about regulatory capture. It's kind of something you have to write about after you have tenure, not before you have tenure, because regulatory capture is not an issue that lurks in the light. And it kind of exists on a spectrum rather than a binary. It's something that is obvious when you kind of know it when you see it, but it is hard to quantify in a very concrete way. Now, I am going to use the remainder of my time to talk to you all about the innovative death technologies that you may not have ever heard about, that are out there and available and on the market. So you're very aware of the fact that casket and cremation are the two options that are available to you. But there are many innovative death technologies that you may in fact not be aware of. This sort of ties back to my point that regulatory capture in many states is creating barriers to entry so that you're not even aware of some of the innovative death technologies that are available. And I would add that it really sort of impedes investment in this space, because investors know that if they make an investment that it may not really blossom when it comes to market because of the barriers to entry. So first, we have disposal of cremains. Now, cremains are cremated remains. And I would say that there are fantastically unique and inexpensive ways to dispose of cremated remains that you may or may not know about. Now, why may you not know about these creative ways to dispose of cremated remains? Well, because it doesn't involve interment in a cemetery. It doesn't involve always the sale of an expensive urn. And so it may not be really publicized. One way you can use your cremated remains is memorial jewelry. So your cremated remains can be turned into synthetic diamonds, synthetic gemstones, synthetic pearls. You know, it's about $20,000 for a 2-carat blue diamond to be made. I have told my husband that if I die, I want him to turn me into the blue diamond. And should he remarry, he needs to use that to propose to new wife. He's horrified. So next we have the creative urns. Let me go to the creative urns. We have sports urns. We have hunting urns. We have decorative urns that you wouldn't even necessarily know are urns, which leads to the next thing, which is thrift store urns. People are thrifting urns. If you go to thrift stores, you will find urns. This leads to something I posted on Twitter yesterday, which is if you found an urn at a thrift store, what would you do if you found ashes in the urn? Believe it or not, it is not uncommon to find urns at thrift stores. We can also turn your cremated remains into ammunition. There is in Alabama a firm that specializes in loading cremated remains into ammo. We can put your cremated remains into fireworks. We can put your cremated remains into artwork. We have a company that allows cremated remains to be infused into vinyl records with the song of your choice put into the record as well. And we have ritual tattoos, meaning your cremated remains can be infused into tattoo ink. Now, I've been told that if you have sensitive skin, this is not a good option because it's very itchy. There is also a company that if you are very tattooed can preserve your tattoos and mount them as artwork. After you pass, that is on the right. And so that is another option. And then there's creative dispersal of ashes, meaning your ashes do not have to be interred at a cemetery. We know that your ashes can be scattered by an ash scattering cannon, sent out in a wicker Viking ship and sent to space. So those are options, but we also have green burial options that are starting to the public is starting to develop more of a public awareness about green burial. I have on the PowerPoint my little slide about the fact that fire-based cremation is not green cremation. I'm not here today to talk about our extraordinarily toxic burial practices in the United States, but suffice it to say, fire-based cremation is better than traditional burial practice, but is certainly not what we consider to be green. As far as environmentally friendly options, we're seeing a rise in interest in at-home funerals. We're seeing a rise in interest in green burials. So what does a green burial mean? It means the body is undressed and unwashed. There are no chemicals. This is, by the way, the norm in Europe. The EU is starting to ban formaldehyde and traditional embalming chemicals. You're stored in a refrigerator or on ice until you are ready for burial. You are wrapped in a shroud or placed in a natural coffin. There's no concrete vault in the ground. I don't know if you're aware of this, but caskets are placed. The casket is placed in what is essentially a concrete casket for the casket. The green cemetery, I'm almost up on time, right? So I need to skip to the good stuff. Living urn, we can put your cremated remains at the base of a tree, because your cremated remains will kill plants, by the way. You're not pH balanced to grow a plant, to grow a tree. But with this urn, which is really cool, millennial innovative death tech that is being funded by a VC, you can be pH balanced to grow a tree. You can be dropped into a memorial reef and grow a reef. And mushrooms are very cool. They're very hip on the green burial scene right now. The mushroom suits on the right, my dean still will not buy me one to wear to conferences. I keep asking. And now we have mushroom coffins on the left. And then we have liquid cremation. You are put into the liquid cremation machine. It is legal in a handful of states right now, but it is growing. It is completely environmentally friendly. There's me. See how happy I am with the liquid cremation machine. And then we have composting, which is slowly becoming legal. It is legal right now in Washington. It just got legalized in Colorado, and it is set to be legalized in Oregon. And I will stop talking now.
Okay, thank you so much. And to be honest, I'm not sure how to follow that. So I think if you have questions right now, please put them in the chat, but I will go ahead and get us started with a question. My first question for each of you, if you were interviewed by a reporter, what do you think they would get wrong about your subject? And what would you want to make sure that they got correct and really helped the public understand about your area of research?
I mean, I can start if you want. I'm still thinking about the mushroom suit and Luke Perry, but I'll try to move on. So I think what I would, what one of the hopes of my project that I'm working on right now is that one of the things that I think people get wrong, because they get it wrong, because either they haven't thought about it or because they're actually like a huge number of discourses out there, sort of cultural discourses supporting this idea, is that really the rules sort of look the same for everybody, but they just happen to have, work out differently for different people. Like, oh, well, everybody pays, everybody pays their debts, or everybody does this, or everybody's got to, there are mythic sort of cultural discourses about like responsibilization of debt, or about how, how we all play by the same rules. Well, it's just sort of the law, right? And I guess one of the things that I would think that I would like people to know, and I would tell, one of the things I tell anybody who asks, which is not usually a reporter, it's usually my mother, is that right, across various, various levels of wealth, the rules are not just playing out differently, they're actually different, right? They're just different. And so when we think about how it is that people become either lose money or gain money, how they lose wealth or gain wealth, it's not just sort of happenstance, right? There's a systematic framework of regulation that makes this happen. It's not just because some people are better with money than other people are, and it's not because some people work harder than other people work. It's because we have rules that foster and enable these types of accumulation or deprivation.
Thank you, Dean Tate.
I would tack on to that answer that it's not just rules that create the inequality, but it's the system of commerce itself that also plays into that equality. So we've got law as it's on the books, and then structures of inequality as they pay out. Why does the pink scooter cost more than the red scooter? Because the company can pay, it can charge and will charge. So we've got law, we've got life as it's lived on the ground, and inequality is built in to not only our legal structure, but our financial structure as well.
I would say I'm really troubled at the way in which sometimes when we try to render assistance, we make things worse. And I would put up an example of that in the form of the reimbursement for death care expenses through the recent COVID bill, which has a cap of $10,000 on expenses. When people are going to go in and there is a cap of $10,000 that they can spend, the funeral directors are going to want them to spend up to $10,000. And that's going to drive price. And I understand that they're proceeding on the assumption that NFDA says that the average funeral is $7,000. That's a really nice funeral. It is really an unnecessary cost to spend $7,000. There are more affordable paths than spending $7,000 on death care services. I spoke on a recent podcast and I didn't know my husband was listening to it, but it's fine. I'd say it to his face. I told them that I was going to be putting him in a cardboard box, and it wouldn't be a nice cardboard box. It would be an inexpensive cardboard box. He listened to the podcast. He was horrified. But the point was, I'm not spending $5,000 on a casket with a satin lining and a memory box. It's like the most expensive piece of furniture in our house that I'm going to own for 3 days and put in the ground. I'm not doing that, right? It's absurd to me. And I see families who are living at the poverty line, and this is what they are being sold. And they're being told, if you love this person and you want to honor them, this is what you will do. And we need to shift the norms there.
Okay, great. Another question I have, and I think you all probably could write a thesis on this, so maybe just providing a brief answer, but if there was something substantial that you could make happen in your area of research to move the needle, so maybe not a complete fix, but if there's something that you think either the law or whatever entity, what would move the needle maybe in a substantial way, even in the short term in your area of research?
I'll say if we have the equivalent of 509 accounts for death savings to do at need before death investment that are tax incentivized savings accounts to save during lifetime, that I think would help prompt people, where you could do automatic withdrawal from paychecks into tax incentivized accounts, which, unlike 509 accounts, were structured to benefit lower and middle income taxpayers. That would help move the needle on my topic.
Very interesting. Thank you.
I would advocate for a federal prohibition on gender pricing discrimination in goods or services. But being the good tax lawyer that I am, I know that any legislation can be worked around, but I'd at least start there. I'd like it for its expressive value, if nothing else. But why go small when you can go big? I'd like to see the ERA get passed.
Oh, great.
Yeah, I'll just go with all of those. Those all sound good. I'm spectacularly bad at solutions, so I'm really not sure what to say. I think there's from the small, which is just sort of, again, this piece, which is the education about sort of financial regulation and the regulation of family money and how it looks for people and how it looks spectacularly different for different people. I mean, there's just so many parts of it you could do. I mean, and part of it, something all of us have talked about before, sort of regulation of, of the trust industry and trust laws, which is a sort of a losing battle right now. I think you could change, you should change all kinds of tax laws. So it's really difficult to think of one piece where you could really make huge headway. So I guess I'll just start with the sort of understanding the way that, again, certain families are sort of privileged and certain families are not, in terms of how they get money and how they don't. I guess this wasn't actually part of my talk. I was just another part of what I'm working on, even changing things like, child support rules. I mean, child support rules are terrible, and child support calculation and child support, what counts as contributions, and, the sort of the really punishing nexus between receiving government assistance and being in child support arrears. That's an area where you could have a huge amount of reform and, really benefit, benefit populations, and especially, most of the burdens and harms of child support right now falls on Black fathers. So that would be something where you could reform family money in a positive way.
Yeah. Great. Well, that actually puts us right up to time. So again, this was an incredible panel. You all covered so much ground in a very short amount of time. So I want to thank each of you for your time. And again, thank everyone for joining us here today. And Austin, I don't know if you want to give one more reminder about our Roe v. Wade event next week. But if not, I thank you so much. I learned so much today. And I just appreciate all of your time so much.
Absolutely. Thank you so much, everyone, including Caitlin. Thank you for your very good questions, which really tied it all together. Just to remind everybody, next Monday, Preserving Roe and the Rule of Law. You can go to the ACS website to register. Hope to see everyone there. Thank you to our panelists, and have a good afternoon.
Thank you, everyone.
Thank you.